Contesting a will can be a complex and emotionally charged process, often involving intricate legal procedures and personal considerations. Whether you believe that a loved one's will does not reflect their true intentions or suspect foul play, understanding the steps involved in contesting a will is crucial. This guide will walk you through the essential steps and considerations to help you navigate this challenging process. Understanding the grounds for contesting a will. Before taking any action, it's important to understand the legitimate grounds on which a will can be contested. Common grounds for contesting a will include: 1. Lack of testamentary capacity. To create a valid will, the testator, the person who made the will, must have had the mental capacity to understand the nature and extent of their estate, the act of making a will, and the implications of including or excluding particular beneficiaries. If you believe that the testator lacked this capacity due to mental illness, dementia, or other impairments, you may have grounds to contest the will. 2. Undue influence. If the testator was coerced or manipulated into making or changing their will, this constitutes undue influence. This can occur when someone in a position of power or trust exerts pressure on the testator to benefit themselves or others unfairly. 3. Fraud or forgery. A will can be contested if there is evidence that it was created or altered fraudulently, or if the testator's signature was forged. Proving fraud or forgery can be challenging, requiring substantial evidence and often the testimony of handwriting experts. 4. Improper execution. Wills must comply with specific legal formalities to be valid. These include being in writing, signed by the testator, and witnessed by at least 2 individuals who are not beneficiaries. If these formalities were not followed, the will might be deemed invalid. 5. Revocation. Will can be contested if it was revoked, either by a subsequent will or by a physical act such as destruction. If a valid revocation occurred but is not recognised, the will may be contested. Considerations and potential challenges. Contesting a will is not only a legal challenge, but also an emotional one, often involving family disputes and strained relationships. Consider the following before proceeding. Emotional impact. Understand the potential emotional toll and the impact on familial relationships. Weigh the importance of your legal claim against the potential for family discord. Financial costs. Legal fees and court costs can be substantial. Assess whether the potential financial gain justifies the expenses involved in contesting the will. Time commitment. The process can be lengthy, often taking months or even years to resolve. Be prepared for the time commitment required. Strength of evidence. Ensure you have compelling evidence to support your claim. Weak or insufficient evidence can lead to a failed contest and additional costs. Contesting a will is a significant legal undertaking that requires careful consideration, expert legal advice, and a thorough understanding of the grounds and processes involved. By consulting an experienced attorney, gathering strong evidence, and being prepared for the emotional and financial challenges, you can navigate this complex process more effectively. Whether seeking justice for a loved one or ensuring a fair distribution of assets, understanding how to contest a will is the first step in protecting your rights and interests.